First case we'll take up this afternoon is State of Tennessee versus Megan Boswell, 72869. Are you going to have any proof, Mr. Sproles, with regard to your bond, motion to reduce bond? Was the state going to have any proof?
No, Your Honor.
Just argument?
Yes.
All right, go ahead, Mr. Sproles. And we've already had a bond hearing back in May 28 of 2020. So what I'm interested in hearing is what's changed since the last bond hearing.
Judge, do you want me to?
Yeah.
podium or-
Either way.
Judge, our position and the purpose for filing that second bond motion is the proof has not changed since Your Honor heard that proof. The only difference is that Ms. Boswell has been in continuous custody since February 25th of 2020. So she is closing in on 2 years that she has been in custody. Through no fault of the state's, the discovery process has taken that long just because of the volume of information that we're dealing with. And, you know, in looking at the factors, you know, we would assert that she is not a flight risk based on the factors that we have laid out in our motion. And we would remind the court that the purpose of a bond is to ensure continued appearance in court, not as a punishment. So we would ask the court to take a second look at her bond situation. And excuse me. And as you said, the difference since the court looked at it the first time is the passage of time that has gone on.
All right. I think one other difference is that she's now stands charged with first degree murder. I don't think that indictment had come down.
Had it not, I trust Your Honor on that, but I'm sure we anticipated those charges at the time.
Your Honor, there's been one other difference. That is that since that bond has been set, we've asked for the aggravated enhanced punishment of life without the possibility of parole. We'd also point out the state's been diligent. We have a trial date, and we hope to meet each one of our deadlines. And for that reason, we oppose any reduction in bond. And again, there's been no real showing of any substantial change that should change the court's setting of the bond.
All right. I appreciate counsel's argument, and I really appreciate the fact that the arguments were brief. Having heard no proof of changed circumstances other than the passage of time, the fact that the grand jury has indicted her for first degree murder and I think felony murder, the court's going to rely on the proof that I heard at the previous bond hearings, the findings of fact that the court made, and conclusions of law that the court made. And I'm going to continue the bond where it is now, and I'm going to deny the motion for reduction based on the proof and the findings that I made earlier in this case. We've had the motion hearing for the bond reconsideration. Any issues that either side wants to take up?
Yes, Your Honor, for the state. And I think you had mentioned it briefly, alluded to it. We filed recently a few motions, one for reciprocal discovery, one for a notice regarding expert testimony regarding mental health and mitigation regarding any proof pursuant to State versus Reed case. And we've just recently filed those and provided those to defense counsel. We thought it'd be prudent to set a date for those. We have other deadlines to set a deadline for responses for those motions we've just filed.
All right. For those, well, two of the four motions, one of them is reciprocal discovery, and that's just a matter of course. Two of them have to do with the potential mental condition defense and or mitigation, is give the defense enough time to prior to trial to gain that information if it's there, and then have the state with enough time to respond to it. I think what we need to do is have the deadline for the defense to file notice of a mental defense or mitigation be May 1st. And then that will give the state 30 days to respond to it. And we can hear, if there's any motion to hear on that or any argument, we can do that on our. Do you want to hear those during July 28th when we have the other motions?
It's too close up to trial. If we needed, it's hard to get one down.
I guess, Mr.
Judge,
Cross,
can we set that back about one, in the event that we needed to retain or have a expert review in the event there was, I think 2 months prior trial would be cutting it a little close.
okay,
I think June would be appropriate. That would give us 90 days out. And I think that would give defense counsel adequate time to respond and determine what they're going to do.
I had set that at 1:30 originally. I have motions in another murder case that afternoon and the following afternoon, if it takes more than one afternoon. Why don't we start this I've got a few cases set that morning, but let's start this at 9 o'clock.
That's fine, John.
We'll
Are we talking about?
April 7th.
April 7th. That's
Mhm.
fine, Judge.
So April 7th at 9.
Boswell faces several charges related to her child's death, including 2 counts of felony murder. Right now, she's the only person facing charges in the death of Evelyn Boswell.